client files bankruptcy and the house is sold after the bankruptcy, am I entitled to a full commission? Gosh, that's a good question. So if you represent a client and there's a notice of default, notice of sale, they file bankruptcy, and eventually they're going to sell the home. Do you as real estate agents, are you entitled to your full commission? 100% yes. Yeah. Your ability to earn a commission, earn a living is separate and apart from the bankruptcy stuff.
Your listing agreement is dated after that.
Yeah, well, yeah, technically if you sign a, that's a good question. This issue didn't come up, but might as well bring it up now. So if you're a listing agent, bankruptcy, get a new contract signed. Because technically that contract is technically kind of void. So you want to make sure you get a new agreement signed after the bankruptcy. Very important. But even in bankruptcy, if we're able to pluck that asset out of the bankruptcy estate and sell it, you're still entitled to your full commission. You know, if you want to sell it for 6% and the bankruptcy court, I guess technically the bankruptcy court could say, well, we're willing to give you 5%, but normally they don't. But there's nothing to impact your commission. Bankruptcy will not impact that, and it's important because you guys work hard in what you do. So, any questions on that?
So you need to get a second listing agreement after the BK?
Yeah, no, after the filing of the BK. So listing agreement, filing, I would get a new listing agreement signed. This is the why. If you have a listing agreement and you file bankruptcy, and something goes a little haywire, and let's just say they got another agent, you brought a qualified, that magical language, a qualified person, and you're entitled to the listing for some reason, or you're entitled to the commission, as well. You're entitled to commission for some reason. That contract, that obligation arose with the client before you filed. And so there's a breach of the contract, and then there's a bankruptcy. You can say, well, you breached my contract. Yeah, but that obligation arose before I filed bankruptcy. So I have no obligation to honor my agreement with you. That's the deal. And you want to be able to get an enforceable contract after the filing.
So as an attorney, would you advise another listing agreement?
Yes. Okay. Yes, definitely.
Listing agreement, bankruptcy, listing agreement in escrow, bankruptcy. Get a new listing agreement?
Oh, yeah, that's a good question. Well, there is an element of, the whole reason to do the new listing agreement is to deal with the contingency of a breach of a contract in which you're entitled to money that you don't get. The reality is that so infrequently really happens. What might happen is, you're a listing agent for a certain period of time, someone comes in, and you show them the home, and they say, hey, wait till the exclusive expires, I'll buy it without the agent. You guys know in that scenario, the seller can be liable for your commissions. All right? That happens. So, and that's really what you're trying to protect by doing this second contract. In your situation, I wouldn't worry about it. If you're in escrow, it's going to sell, you're going to get your money.
Yeah, but they could always come back and say, wait a minute, the listing contract's null and void because the bankruptcy wipes out the obligation.
They could, yeah.
So, if you get a new listing agreement after the escrow's open, what happens to the agent representing the buyer whose residential purchase agreement predates the bankruptcy?
Well, if you're representing the buyer, it's irrelevant because it's the seller who filed bankruptcy.
Yeah, but the seller is paying the commission to both parties.
Mm-hmm.
And could the seller come back and say the bankruptcy came after escrow was opened, therefore it wipes out the obligation to pay?
But is it the bankruptcy court paying the money?
No, well, remember, most of the times these transactions happen after the bankruptcy is discharged. Most of the
But
time.
there is a form in the escrow that you immediately get signed that they cannot tax the commission, so you can always.
Well, but I think bankruptcy court trumps that.
Yeah, no, bankruptcy definitely trumps. But I think, the prudent thing would be to really get new contracts
How
signed.
does the buyer's
Or-
agent do it though? I mean, what do you do, submit a new RPA for something that's already in?
Yeah, it's a good question. It's a good question. I haven't thought about
We just
that.
do it.
No,
Yeah.
when?
Just do it by then.
What I would recommend is ultimately, as you said, do it by addendum, reaffirm the contract, reaffirm the terms. It's a one-page deal, and you're done. You don't have to like, here's my 80-page document, please sign it again. Like, oh. But if you do a simple addendum that says, everything we agreed to, you're agreeing to as of this date, which is after you filed. That's probably the best way to handle it. I never had that situation happen factually, but that's probably a good way to do it. Leave it to the president to ask some weird questions. Yeah, it's a good question though.
My concern on that would be that they come back and I filed and we're escrow, and they go, well, I don't want to pay the 6% now, I'm only willing to pay 3%. But I'll agree to those terms, you know,
Yeah, well,
both sides of the partnership.
there's a lot of issues there.
Yeah.
Yep, that's true. Cool.
And that's assuming that they tell us.
What are you talking about? Really? All right, couple more questions, guys. Can I sell a home while the bankruptcy is still pending? We talked about this, yes. If you can sell a home when it's in bankruptcy, you got to get permission from the court, though. Most of the time, though, we just wait until that discharge because the typical bankruptcy is about 4 months, and it's not that big of a deal. Some bankruptcies will last a year. If you know there's going to be issues, you may want to talk about it.